Well, I do object to the setting aside of my motion, Your Honor.
Sir, your objections mean I don't care what you're objecting to. So you keep saying, I object, I object, I object. I think this is your motion to dismiss, right?
Yes, I have a few in there that I've been repeatedly trying to be dismissed.
Which one do you want to start with first?
Well, the recent one I filed, the motion to reject the swearing in and all that, based off the fact that, like I said, I was sent a default motion that I don't know how it even got sent out past the day, but it was never signed or anything. I was also defaulted out the fact that there was a citation that never even presented a court appearance.
Okay, hold on. You're giving me too many issues. You're talking about swearing in. You're talking about a default judgment. Which? Just pick one issue. We're going to deal with it one at a time. So what do you want to deal with first?
Well, my main motion. Well, yeah, the default.
Okay. So was that on the civil infraction? Failed to disclose the CPL?
I suppose that's what it was under. Yes.
Okay. What? Don't suppose it's your motion, brother. Tell me what it is.
Well, it keeps getting.
I mean, that's the only civil infraction.
I have numerous.
Hold on. That's the only civil infraction I see with your name on it. So I'm just confirming that we're talking about that charge.
Yeah, sure.
Okay. So do you know why the default was entered? Did you miss a deadline? Did you?
Well, I was notified. I was called by people that I know within Huron and the police chief stating that I had a missed appearance date. I never had an appearance date scheduled, but I went back looking at the citation. There was no date, and actually, how fast it got issued raises real concerns to me. And then once I received the default in the order,
hold on. Let's take one thing at a time. So you said you never got an appearance date.
Correct.
Do you have a copy of the ticket? Because I've got a copy.
Yeah, I said it's in there. It's attached to my motions.
Okay. Do you have a copy of the ticket?
I do.
Okay. Then I'm going to ask you to look at that copy of the ticket, because my copy of your ticket says contact court for appearance date.
It says contact court for appearance date, where it says appearance date on or before. There's nothing.
Okay, but it says contact court for appearance date. That means the monkey's on your back to contact us.
I will also on the bottom of the tickets it says if you fail to contact court within the specified amount of time. There was no specified amount of time on here. I had no idea when I was supposed to contact the court. I was dealing with trying to get my attorney.
Let me ask you this: did you contact the court?
I was again, as I said, I had no sort of any time frame to contact the court.
Mr. Crucell, this is going to go a lot easier on everybody if you just answer the question I asked. I'm going to give you plenty of chance to give me any argument you want to give. Okay? So don't feel that you have to force your argument into every question I ask. The question was, did you contact the court?
Well, Your Honor, I would have contacted the court if I had a specified.
That's a yes or no. So I'm going to take that as a no. You didn't contact the court. So after 14 days on a civil infraction, if we don't hear from the defendant, we enter default.
It was less than that, actually, when I was defaulted, Your Honor. Which then, again, there was no dates. I had no nothing. I had no notice of any sort of.
Once again, you're not hearing what I'm telling you. The monkey was on your back. The ticket clearly said you contact us. You never did.
And it also specifies right here, if you fail to appear by the date specified, and then on the bottom one, even for the other one, if you fail to answer a citation by date specified, there was no dates.
Okay.
There was no dates.
Okay. Do you have anything to add?
I do, Your Honor.
Go ahead.
The default of a civil infraction, irregardless of whether or not he showed up.
Which I object to the setting
Sir,
aside.
do not interrupt the lady. Did she interrupt you?
No.
Then don't do that. Let's be civil. Go ahead.
Thank you, Your Honor. Judge Green, Mr. Purcell did bring it up again with the Honorable Judge Green, and she declined or denied his motion based on the fact that it was moot because Judge Martin set it aside.
So the default's already been set aside?
Yes.
Brother, why'd you just waste 5 minutes of my life?
Since March 14th, Your Honor.
Which I object to that because there's.
You object to your motion being granted?
No, I object to them setting aside my motion. And I object
No. Wait. Listen. She tells me Judge Martin set aside the default based on your motion.
Yes, but I was never told any of that prior to any of that.
So you want to argue about the fact that you got what you asked for?
No, what I'm saying is the fact that the due process was violated is what happened in this whole problem. When I was defaulted, due process was violated.
So what? She set it aside.
It was set aside to cause damages to me because of what happened with the default.
Well, explain to me how you were damaged.
First off, there's threats made against me, right? Clearly, he's threatening me to issue warrants.
I didn't ask you about threats. I said, how were you? You said you were damaged. I'm asking you, what was the damage?
The fact that I was threatened to come in to pay money or warrants.
How was that damage?
And I was being threatened by Huron police, which I have on record.
What's the damage?
What do you mean? The fact that I had to come in and pay money, or they'd have been issued.
What money did you pay?
Huh?
What money did you pay?
$280. I had the receipt and everything. It was all attached to my motions. They just keep trying to set it aside. And Judge Green never said a word to me about any of that.
It's been set aside. counsel just said, Judge Martin set aside the default. So what that means is procedurally, it's like it's a brand new file. Understood?
Yeah, but that's but that, especially now with the new Chevron overlay, that's just saying that she's just trying to set it aside, that there's no issues.
She didn't try to set it aside, she sat it aside.
But she can't just set my rights aside.
She's not setting your rights aside, she set a default aside because you asked her to.
Well, so if it's set aside, then the money should be returned, correct?
Well, I don't know, did she address the money?
No, she never did. No one did. I
Sir,
explained in my motion.
Sir, I'm gonna hold you in contempt the next time you cut her off. The first contempt, $100. The second contempt, a day in jail. Are we clear on the ground rules for my courtroom? Is that a yes for the
Yes, Your
record?
Honor.
Okay. I'm giving you all the time you need to talk. Don't talk over her.
Okay, I understand. I'm sorry. There's just been a lot that's been going on with this.
And I'm the first time I'm seeing it, so I'm trying to get to the bottom of it.
You're right.
All right. So we started with what motion do you want to talk about first? You said your motion to set aside the default. That was granted by Judge Martin, is what I'm hearing from the prosecutor. Next motion you want to talk about.
The dismissal based off of fundamental violations of my fundamental rights and due process.
Okay. Well, tell me more.
Okay.
Do you have, hold on, let me just cut to the chase. Do you have more than just the fact that you think you have a right to travel?
Yes, Your Honor. Actually,
That's denied. I'll just cut to the chase. That's denied. I don't buy into that argument. Now, you can appeal that decision to the circuit court. You understand how that works? District court decisions you can appeal.
Absolutely.
Okay, hold on. I've denied that motion. We're not going to talk about that motion because I've denied it based on your argument that you have a right to travel and don't need a license. Is there anything else you want to hang your hat on for dismissal?
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying. I object to the
You
denying.
can't object. You can appeal.
What a lot of these sovereign citizens don't understand is that objecting isn't some magic word that stops a ruling in its tracks. It's a formal legal mechanism with specific grounds behind it. I mean, I've noticed this pattern over and over again. These people literally treat courtrooms like they're negotiating instead of understanding that a judge's ruling stands unless it's properly appealed through the correct channel. And like the right to travel argument this guy tried is one of the most common sovereign citizen talking points out there. And it has never once succeeded in an actual courtroom. I mean, at some point you have to actually wonder if these guys believe what they're even talking about, or if it's just a performance for an audience they think is watching.
I'm just letting you know, I'm stating for the record that I am objecting to your denial of my appeal.
That's fine.
Okay.
Circuit court judges have bills to pay too, right? So you appeal me to the circuit court. So you want to talk about whether or not there was a valid reason for stop?
Absolutely.
Then make the argument.
Your Honor, so this officer seen me leaving my house, pulling off my dead end dirt road, proceeded. Like I said, I even told him I've already had this. I've already addressed this. You need to go talk to the sergeant.
Right.
Chose not to. Pulled me over, walked up, just started demanding ID and everything from me. He wouldn't identify himself. None of that good stuff. And then now this is where it's all led to. And I informed him I have body cams. I have my own recording. And like I said, I have.
All right.
Which I object to the.
Hold on. All right, so the one misdemeanor is operate the ORV on the roadway, and the other one is fail to display a valid license. Okay, all right. So that's her response to your argument. They didn't have probable cause. What's your reply to her response?
Well, I object to her terms of operate. There's no evidence that I was operating anything.
Okay, let me stop you. I killed that when I said the whole traveling thing doesn't go anywhere with me. Operating and traveling, as you define operating, or as you define traveling, we define it operating. So hold on, I've already ruled on that issue. You can appeal that decision to the circuit court. We're not going to plow that field again. So now we're talking about probable cause. What I just heard was the township has an ordinance that says nobody can operate an ORV on a roadway. Would you agree that's an ordinance in the township?
Your Honor, I may agree.
Yes or no? Mr.
Yes, I agree with that.
Okay, stop. If that's a valid argument or ordinance, and when I say valid, I don't mean if it's constitutional, if it's, stood the test of a challenge. I mean, if it's on the books, all right? If it's a valid ordinance and the officer sees you doing what that ordinance says you can't do, and he pulls you over, that's plenty of probable cause for the stop. So your motion to dismiss for lack of probable cause is also denied. Do you need me to clarify that ruling for your appeal reason?
Yes, I actually, because Your Honor, I object to
What do you not understand?
no
Sir,
RV.
your objections mean shit to me, okay? I don't care what you're objecting to. I don't expect people to like every decision I make. That's why there's an appellate process. So you keep saying, I object. I don't care.
That "I don't care" line is exactly what this guy needed to hear months ago, because this guy's entire strategy has been built on the idea that repeating an objection enough times eventually forces a judge to cave in. Like, the judge doesn't know anybody at debate over a ruling that's already been made. And this is the same exact energy I see from almost every single sovereign citizen video. I literally just think because they're confident that somehow a substitute for actual legal grounds, and it just never works. Like, Judge Oakley just proved in one sentence that all the paperwork and objections in the world mean nothing if you don't understand the basic rules. Let me know in the comments if you guys have lost any brain cells so far.
All right, it's not helpful for today's process. My decision to deny your motion to dismiss based on lack of probable cause is because there was probable cause, because there was a clear ordinance on the books that the officer thought you were violating. That gives the officer a reason to stop you. Do you have any other reasons why you think these matters should be dismissed today?
Yes, absolutely. First off, they're trying to label what my private property is an ORV. It was not an ORV, and it's not even technically an ORV. If you look up the definition of ORV, it is not an ORV. If you look up the definition of automobile or vehicle or any of that sense, that's what it falls under. It does not fall under an ORV. They're just trying to label it as an ORV is what is happening.
Okay. That seems like that would be an issue for trial, for you to testify, maybe me to see some photographs, maybe the officer to testify, and then I'll decide whether or not it meets the definitions of the statutes. Would you agree with me? Because that seems like a triable issue.
I suppose, yes.
Okay, well, this isn't the trial.
Well, I understand.
I don't think it's scheduled for trial. Right, this is just motion. All right. Any other issues that you want to hang your hat on as why it should be dismissed? It being these files.
Like I said, from the beginning, it's like the officer had already been notified 2 times prior to this that what I was doing was lawful, that what I was doing was not an ORV, which I had stated to him.
But that's
witness to that
Mr.
as well.
Purcell, with respect, that's all your opinion. Obviously, the officer had a different opinion about all those things. Once again, I got to have evidence, right? I got to take testimony. I'm going to hear from you. I'm going to hear from the officer that wrote the ticket, and then I'm going to decide at formal hearing whether or not what you did was reasonable or not reasonable. But today's just motion day. Today's not the trial. No testimony is being taken.
Oh, I understand that.
Okay. Anything else today?
Well, I guess that's no, but like I said, again, for the record, I do object to moving forward. I do object to anything moving forward from this point.
File your appeal.
No, that's fine. I will.
File your appeal.
I'm going to. That's fine.
Okay. All right. Now, the 200, let's get back to the $280. We'll talk about a jury trial date. Are you going to represent yourself at a jury trial?
Yes, Your Honor.
Good luck. I'm not taking you to law school on the jury trial day. I'm going to assume and treat you accordingly that you know the rules of the game.
I understand, Your Honor.
You don't.
Oh,
You might say that. You don't understand the rules.
I do.
Okay. How many jury trials have you had?
None, but I have all the evidence.
How many jury trials have you had?
Your Honor, none, but I have all the evidence.
The evidence isn't the rules. There are a lot of procedural rules that will trip you up if you don't know what you're up against, and you don't. I'm going to suggest to you that even if you want to handle your evidence presentation yourself, you might want to get an attorney involved to help you with the procedural rules, because once again, I'm not going to take you to law school that day. I'm not going to subject the jury to that. It would be a waste of their time. You understand that? All right. Now, and I'm not trying to talk you out of a jury trial. Believe it or not, I'm trying to save you from yourself right now. If you want to have a bench trial, I will be much more lenient with you not knowing what you're doing procedurally, because then it's just our time. But when it's a jury in here, I'm going to run the most efficient jury trial I can. And that means I'm going to treat you like you're an experienced lawyer and know all the rules.